So that's anything from what we're talking about today, disputed deputyships. We'll come on to sort of disputed LPAs and also health and welfare matters, so decisions about where someone should live, medical treatment. They tend to get quite disputed as well, so we get involved.
I like the fact that you've got a plan for today, which means you've never watched a Nellie on the sofa ever before, because that plan will go out the window, I'm sure. I mean, disputed deputies. Before we sat down, we were talking about this a little bit, because there's different reasons why a deputyship could or would be disputed, isn't there? Yeah. So let's start with that. So LPA, because I don't know who we've got on. So LPAs and deputyships are slightly different, aren't they? Deputyship goes through the court protection.
Yes.
And you're a deputy for the court.
Yes, essentially. Yes.
Essentially.
Deputy for P, and you report to the court.
And that's the difference between the LPA and the deputy as such, isn't it? The deputy reports to the court. They have to send in annual accounts.
Yeah.
And if they make a mistake or they do something wrong, then the courts are there to be very polite and supportive and shout at them a lot.
The court protection is very supportive, so they are there to help, and they're focused on the protected party, their best interest. So it's similar again for an LPA. If you do go wrong, the court are there to step in. It's just the supervision is not as much as it is for a deputy, because you've not got to do the annual reports, and also the LPA, so the person appointed, the attorney, has been specifically chosen by P, the donor at the time, when they were able to do that.
Where the deputy is at a point where somebody's already lost capacity, so they're appointed by the court.
Yes.
And that's why they're a court-appointed deputy rather than just I've chosen them to be. Just so for those people that are unaware, so if you've got a client that lacks capacity to manage their own finances, then a deputy would either be appointed by the courts or it can be applied for as family and friends and things like that. And then deputy essentially becomes fully responsible and in charge of financial decisions, full stop, don't they?
Yeah, so there's two types of deputyship. You have the property and finance, and then the health and welfare. Again, same as the LPA, there's two. Health and welfare is a lot rarer in the court of protection, so to have an appointed deputy. Property and finance, much more common, and once they're appointed, they then become responsible for P's property.
So let's clarify on that health and welfare thing, because this is one of the bugbears that we sort of hear, because there was an urban, because of the health and welfare being rarely given, that actually created an urban myth in local authorities. So as a social worker, I was always told when I was in the local authority that you can get lasting powers of attorney for finances, but they never give lasting power of attorney for health and welfare.
Deputyship?
No, it was always, the urban myth was health and welfare for LPAs, because of that piece about the deputyship being rarely given for health and welfare. But that's not true, because LPAs, they're not given by the courts, they're given by you. So if I want to give you my LPA for health and welfare, I can. It's just signatures. Deputyship's slightly different in that way. But deputyship for health and welfare, it is rarer. But I've always been told that if somebody's never had capacity, so if you've got a child that's born with disabilities, somebody with special educational needs, something like that, they then turn to 18 years old, mum and dad are still their main and primary carers, the chances are they will get deputyship for health and welfare, whereas if somebody is 70 years old and they've got dementia, it's less likely that they would be given health and welfare.
I think that's true, but it's more based on the circumstances rather than just those facts alone. So when you think about it, when there's a child who has special needs and care needs, the parents are there looking after them. It makes sense for them to be the ones that carry on acting as the health and welfare deputy if they're appointed to make those decisions. So that protected person is going to need decisions about schooling, I guess, the care, where they live, who they have contact with, and that's going to go on for many years. So it makes sense in those circumstances to appoint parents if they were to apply to be health and welfare.
Because they're continuing on in the role that they've been doing for the past 18 years, essentially, aren't they?
Yes. Whereas for the elderly person, I mean, that they'll still need decisions. It might be more medical decisions depending if anything happens. It's more there's lots of conflict in views. One child might say one thing, another child might say the other. Medical professionals will be getting involved. So I think what the court preferred to do in that case is say, well, here's the decision we've got to make. So for example, does mum go into a care home?
So they break it into a specific decision rather than making it a generic deputyship order.
Yeah, so it won't say I'm going to give son all the power, he can make all the decisions. They'll say, well, I'm going to the court are going to make the decision, does mum go into the care home, what's in her best interest? They deal with it sort of decision rather than
decision specific.
Yes,
which is the way it should be dealt with. But
yes,
yeah, I think it's that when you've got a child, I suppose it is slightly different, isn't it? Because you've got parents that can't just stop being parent because their kids turned 18 years old.
Yes,
It just, I had an argument with somebody about that the other day, that you're still a parent even when you're 40, when they're 30, to be honest. It doesn't stop.
Yeah.
Although I wish it did financially.
Yeah.
It'd be nice, wouldn't it? So I know that was a little bit off topic, but it was more for my own curiosity, to be honest. And I'm sure I hope other people took stuff from it. So why would a deputyship, either finances or health and welfare, why would that be disputed? Because the courts have made a decision, they've appointed a deputy, they've done that in best interest, so
normally the disputes where we get involved is before the court have appointed, so it's during the application process.
Oh, okay.
So someone may apply to be a deputy for somebody. You have to serve notice on sort of close family members, certain people. You have to notify at least 3 people. And that person who's notified may say, oh no, I don't think they're a good choice, I can do better, or they just shouldn't be deputy.
Yeah.
So that's when it becomes disputed if they file an objection and say, I don't agree.
So to be really extreme on this, you've got 2 sons. One son's not seen mum for 20 years and is a huge heroin addict, but all of a sudden finds out mum's got dementia and got £4 million in the bank and wants to be a deputy. Yeah. And then you've got the daughter that's been looking after mum all day, every day, is got 2 kids and married and life just going on around her, sort of thing. Yeah. Member of the PTA at the school and all those sorts of things. Yeah. She puts in a deputyship order, all of a sudden it's contentious. Yes. Because there's 2 requests going in.
Yes.
So it doesn't need to be necessarily the 2 people arguing with each other. It can just be that there's 2 requests gone in.
Yeah, so 2 conflicting applications, and then the court will see, well, who's best interest of P, so mum's best interest for them to be appointed, so who's in her best interest. And it may be that they reach some sort of agreement and say we'll do it together. That's always an option. So they don't need to be in dispute. You say they could just both put the application in. They think they're best, so why can't they act together?
Yeah. And the judge, they can do that almost like through mediation, I suppose.
Yes.
And come to an agreement.
Yeah, you'd reach some sort of agreement. It'd really become more disputed if they said, I don't think he should be deputy at all. Sometimes I think what the court's preferred approach is if there's more than one person applying, and in a case like that where there's large assets and it sounds like that's going to be quite a complex estate, the court would just say, well, we'll just appoint a professional, gets rid of any arguments.
And that's where the panel deputies come in.
Yeah, and then they'd go to the panel, or sometimes the brother and sister in that case might say, well, we quite like this firm here that offer deputyship, we'll agree if that firm are agreeing to act.
And again, almost like a mediation process, okay, we've stopped the argument, these 2 people have agreed to go down this route.
Yes.
That resolves the issue.
Yeah.
So there must be a lot of, within that initial parts of that contention, it's not just going to the court and sort of putting it across as best interest to the court, your role, it's that initial conversations with the other parties and trying to resolve it almost outside of court.
Yes, and it is really, there's a set procedure in place which does encourage that. So, like say you serve your application, you'd get the objection back. So in that example, one person would apply for a deputyship, they'd serve it on the brother or sister, and then they would object and say, I've also put an application, so I think I should be deputy. Yeah. At that stage, our role is then to reach out and to sort of correspond with the other side and say, we think we should be deputy for this reason, sort of, this is why it's in mum's best interest, and they'll probably come back and say similar, or they may say no, there's no way I'm going to let you act. What the court will normally do is they will list the initial directions herein, so you'll attend that and the court will say, what do I need to take this case to a final trial where I can make a decision? what evidence do we need? So we'll agree some directions, or the court will set the directions for the case. But the first direction is normally sort of witness evidence, but then a dispute resolution hearing.
Yeah.
So before we get to a full trial, we have this more, I wouldn't say informal, because it's still a formal hearing, but you go there, you put forward your case, and the judge says, I'm not making any decisions, but listening to the evidence that's available now, I would probably say this is the likely outcome. And that really helps the two people, or sometimes if there's more, think, well, this is what's probably going to happen. Let's try to reach an agreement.
Yeah, we need to come to an agreement or step away. Or
Yeah.
So when you've got cases like that, where you've got one family member arguing that the other person isn't fit and just, I'm just curious on how many of those end up being resolved before the judge gets involved as such. Do you know what I mean? Like we were saying, that, you know, how many of those get resolved at a mediation type stage, and how many are they just continue screaming at each other all the way till the end?
I think it's difficult to say. I'd probably say over half of them get agreed.
Really?
Because you'd hope that you'd got solicitors for both sides, they're advising.
Yeah.
And unfortunately, the costs of these proceedings are very expensive. And the starting position is that P pays the costs.
Yeah.
So it's not really in their best interest for you both to keep arguing, racking up all these costs, and then they pay for it.
So P pays for, even though it's contentious, P pays for all of the costs?
Yes, so that's the starting position.
Yeah.
Is that proceedings relating to a person's property and finances, the costs are met by P.
Yeah. So if I was just applying for my mum, nobody else was applying, just me,
yeah,
I could essentially take the money from her bank account to pay for it as such. Once I've got deputyship.
Once you've got the deputyship, and then there are slight rules about costs in terms of, it depends, they need to have over a certain threshold to recover all of the costs. If it's below, I think it was 16,000, then you can only recover fixed costs,
right.
So there will be a shortfall. But providing they're over that, which most cases are, because sometimes there's no point to the deputyship for the lower value, your costs don't have to be assessed by the court, so you don't always recover all your costs, but the court will say, well, these are the costs you've incurred, this is what we're going to allow you to recover.
So the costs court?
Yeah, the costs court.
See, I know my stuff.
Yes, yeah.
We had Paramount Legal, no, they're not Paramount Legal anymore, are they? They're Peak costs.
Oh yeah, Peak, yeah, they're very good.
So I learned about the costs court. I don't think that's the right term, is it?
I think so. Yeah.
I know I kept getting it wrong on
the
that.
SCCA.
Too many acronyms.
Yeah.
So essentially, you've got two people contesting. Do you know what? I'm genuinely surprised it's over 50%. The reason I was asking that, because obviously when you're working in this side of the field, I suppose, you only hear the negatives.
Yeah.
It's like older adults. You could almost become depressed, because everyone that rings me up that's over the age of 70 has got dementia. So you could almost start to think, oh my God, as soon as you get to over 70, the chances of you getting dementia are sky. Everyone we meet is in a care home.
Yeah.
We don't meet the fit 95-year-olds that are still going out running every morning. We don't meet the healthy 80-year-olds that are still going to pubs on a Saturday afternoon and things like that, because they don't need us.
Yeah.
And it's the same in your position, I'd guess. I would have thought that the majority of contention was going to be screaming and arguing all the way through. But actually, it's really nice to hear that actually these get resolved early on.
Yeah, because the other thing to think about is what we always tell our clients is, if we go screaming and fighting all the way, we'd never do that, because there's a way to approach these proceedings. You need to be cooperative throughout, really, because you're applying to be deputy. If you kick up a fuss the whole way through, and this is what we say to clients, if you dispute it all the way, the judge is going to say, well, I've got two people here, clearly they can't act together, there's a lot of dispute. Whoever I appoint, the other one's going to start picking faults from the decision, so I'll just appoint a panel deputy. Yeah. So that's the advice we would probably be giving to clients. And
you'll either end up with everything or nothing sort of attitude. Yeah.
And coming back to the costs, so although the starting position is cost are met by P, the court have discretion to sort of move away from that. So if they feel one person's conduct has been so unreasonable, they may say, actually, you can pick up the costs. for these proceedings.
So if you've got, like we said, the heroin addict son that hasn't seen him for 20 years and the daughter is trying to agree something with him,
yes,
and he just refuses all the way to the end,
yeah,
and she's being completely reasonable and saying, well, let's share it, let's do this, let's try it this way, and he's just, no, I want full control.
Yeah.
Then essentially the judge could turn around and say, you're paying your own bill.
Yeah, so you'd be asking the court to say, well, I think we're only here because of him. Please can you make an order that he bears the cost? And he may get an order that he bears all the costs, or he may say, well, you can pay your own or half the other person.
So he could potentially end up paying the other party's costs as well, potentially.
Yeah, potentially.
I love justice.
Yes.
Do you know when you do? Because we've had serial litigants and things like that come to us, and they push and push, and you're sat there going, I don't understand why you're even pushing this through. This isn't a case, but you seem to be so angry that you're just going to waste everybody's time, including the courts, to get a result that you're not going to get. It's quite clear you're not going to get. So it's kind of nice to hear that people like that do end up having justice.
Yes, sometimes. Unfortunately, we do see it too often where we have someone saying, look, I'm going to go, I'm pursuing this. They almost say, look, I'm pursuing it, I know it's unreasonable. And we tell them that, and we say, look, this is not in P's best interest. That's all the court care about at the end of the day. What's in P's best interest? But for some reason they'll still pursue it.
It's people's psychology behind their decision making sometimes is just it's reasonable to them, even when it's unreasonable. So family dispute is one of the reasons, but you also mentioned before we came on about local authority dispute as well.
Yes, so sometimes the local authority may get involved. We often see that in elderly people. Maybe they're in a care home, maybe the family aren't in touch as regularly, so they actually don't know what's going on in the ground. They may visit 2-3 times a year. The local authority get involved and they start dealing with the care fees, and they say, well, actually, we need someone in place who can actually deal with this. The local authority can only do so much.
There's a limit on the finances a lot of the local authorities can manage, isn't there?
And they can be
send out
appointees. They can deal with sort of benefits and that, but when the care fees are quite expensive, so they can't normally deal with that unless there's sort of funding in place.
But I think even their deputyship teams, because some of the local authorities have deputyship, they have set limits on the estate size that they can manage. Because I know we do stuff with, I can't remember, one of the city councils, and they send it out to their panel sort of thing of private deputies, because it's too much, it's too complicated, it's too much money. I suppose if you've got a person that owns a business maybe and has got investments and things like that, a local authority deputyship team might struggle.
I think it's more in terms of the resources they probably have available, because they manage loads of people. But the local authority, they may apply to be deputy themselves, the local authority, or they may apply to court and say there's no one here acting, we need the court to appoint a panel deputy. And that may become disputed if the family are then notified, which you'd expect them to be, and they say, actually, I think I should be acting here. And then the local authority may agree and say, oh great, we've got someone who's willing to act.
I could well believe the local authority would go, thank God for that, we can wipe our hands of this case.
But it depends on the circumstances. They may say, well, I don't think you're suitable, maybe they've not been around. It could be like similar to that guy, mum, he's a heroin addict, got back in touch. He's now realised, oh, look, there's this money here I can control. And they may say, no, we don't agree to your appointment, then it becomes disputed.
Because the local authorities still have a safeguarding duty, don't they? At the end of the day, if they think that person is doing it for nefarious reasons, they still have to safeguard.
Yes, and again, they're acting again in P's best interest. They want to make sure whoever is appointed should be appointed and is appropriate. In
those situations, then you've got a family member against a local authority. That must be so intimidating, because they're going against the government. That's, because it's something that, I was told as a social worker, when I knock on somebody's door, I don't need to feel nervous because I've got the weight of the local authority behind me. Not that you ever actually think like that. When you knock on somebody's door, you're actually thinking, I wonder if they've got tea and biscuits. But they've got the perceived power, I suppose, that perceived weight with a local authority. It must be, for your clients, they must be sat there going, I'm never going to win this, am I? It must be quite nerve-wracking.
I think.
Oh, okay. Oh, we've had a question. Sorry.
Okay.
No, it's okay. No, and go for that first.
Yeah, I think sometimes what they clients will say to us is that, the court are just going to go with whatever the local authority say. They can make up whatever they want, and the court will agree. But we have to say that that's not always the case. The local authority have their own job to do. They're on the ground. They see what they say.
Yeah.
Say what they see and put forward their case. But there's no reason if the local authority dispute a family member being appointed, that doesn't mean it's the right answer. If we can show that actually it is in P's best interest for them to act, there's lots of advantages, then the court will agree as well.
And let's be clear here, because one of the 4chan, I think that's the name of it, isn't it? 4chan, these forums and Reddit and things like that. One of the conspiracy theories that we get told a lot, more often than I really would hope, is that the local authority get backhanders from the courts for every deputyship, and they local authority. This just doesn't exist, does it? It's not. There isn't a thing like that. That's not. There is no financial incentive for a local authority to take on a deputyship order. In fact, it costs them money, doesn't it?
Yes, no, I imagine it does. Also, the local authority, their rates are lower.
Yeah.
So you have the guideline rates that solicitors can charge in the court of protection, and they're sort of set by these guideline rates. The local authority rates, from what I understand, are significantly lower than that.
And that's not just for local authorities, that's for all professional deputies that aren't registered solicitors.
Yes, I think, yes.
So if I wanted to act as a professional deputy, I could charge, but I couldn't charge the rates that you guys charge.
Yes, that's
because
it.
I'm not a registered legal RSA solicitor.
Yes, that's it.
So it's going to cost some money to run a deputyship.
It's going to add pressure, because the resources they have aren't as. Because imagine they've got so many deputyships. Each firm might have a lot of deputyship, but compared to the local authority managing
and then they've got their appointeeships to manage as well, on top of those deputyships. So I would guess there's hundreds and hundreds of cases that they've got on file. And I'm sure some of them are fairly simple. The care home fees are set up as direct debits, and the house has been sold, and all of those sorts of things. And I suppose once it's set and running, it's running
along nicely.
Until something comes along to throw a spanner in the works, and then all of a sudden you've got 6 months' work. Sorry, Fumi, you said we had a question.
Yes.
Oh, you want me to read it as well? Are these orders for applicants/respondents to cover costs common?
No.
So the other party.
Yes, where the court deviate from the general position. So unfortunately, no, they're not that common. You've really got to persuade the court that, look, this person has pursued it unreasonably. And you can put forward a good argument to say, look, I've applied because I thought it was in P's best interest for this reason, this reason, this reason. We've ended up with a deputy, it may not be myself, but these proceedings have still reached best interest for P. So technically they're not won, but the proceedings have been worthwhile pursuing. So it is difficult to really...
So you really do have to justify that these proceedings were not necessary in any way, shape or form.
But making those early offers will certainly come into it. So you'd make offers, and when it comes, the court then made their decision, deputy's been appointed, whoever it is. If you want to then try to recover your costs, once that decision's been made, you can then say, looking at cost judge, here's this correspondence 6 months ago where I put forward this same outcome we've now got. We could have saved all the costs for that last 6 months, and that's when the judge is going to be more persuaded to say, actually, you make a point.
So evidence is key, and following the processes.
Yes. And just making sure if you're looking to get a cost order, just make sure you've been reasonable yourself, because these things can get heated, and if people start throwing mud at each other, and
you've got a lot of emotion involved as well.
Yes.
You've got people that mum is all of a sudden very unwell, or dad is very unwell. If it's something like dementia, which is degenerative, they know that there's a time frame here as well. So this is the start, or they could be midway through a journey to. Kirsty told me that I'm not allowed to say this anymore, so we've got to be really plain about this. To their death.
Yes.
It's the start of their death. Kirsty's a death planner.
I think I met her.
Yeah, she's lovely, and she was quite, and she was right. We have to. They die.
Yes.
It's death. It's as simple as that. So you've got two family members potentially dealing with the emotion of that, then dealing with the emotion of not necessarily that, because a lot of the time these families haven't fallen out prior to this, have they? It's the deputyship and the mum going into care that's caused the argument and the rift. So then you're dealing with the emotional damage of a relationship breakdown as well, and a fresh relationship to breakdown. I mean, I'm not suggesting you and your partner ever argue, but in those first few minutes of an argument, that's when your emotions are at the highest, and you say things that you wouldn't normally say and do. So I suppose you, as a solicitor, you've got all of that to deal with as well, and identify, is this for nefarious reasons, or is this just people being in an emotional situation?
And that's where we try to take out those, because our job, we don't get emotional about their cases. We need to take that out and say, look, let's look at the facts here. These are the facts, this is what we can use, this is what the court are going to look at. And sometimes we've seen cases where actually both people on the opposite end are really passionate about wanting to be deputy for the same reason. For example, mum may have said, while she's in the care home, lost dementia, oh, I really want you to be my deputy, I really want you to look after my finances. And then they've told the other person that, so they're almost, it's because poor mum she's got dementia, she doesn't understand.
She hasn't got capacity. She's saying what she says there and then to that person.
Sometimes just to please them, and they're saying, no, mum really wants me to be deputy. Everyone's saying, no, mum really wants me. So they're going to sort of end up in a dispute.
But you can have joint deputies, can't you?
Yes.
And then that's the answer in those situations. Will both of you be a deputy?
There
you go.
They just need them to act. That's more difficult if maybe there is the relationship fell apart between these two people before the proceedings. So if they never got along, sometimes that may not be an option for them. So
what other reasons would you see contentious deputyships?
So we mentioned, touched on local
families, local authorities, family fallout.
Yes, sometimes a contentious deputyship doesn't have to have another party. So sometimes you could apply to be a deputy. The court could look at the application, because it's not just a tick box exercise for the court. They really do look through this application, look at, are you suitable, what are the finances, and they may look at it and say, actually, I think maybe you're not the right person to be the deputy. That would be more on the case where, again, high level of assets, maybe some complications, so maybe those assets might be complicated, maybe there may be high expenditure every year, so sort of care fees, that can get quite expensive. And the court may say, actually, I think maybe we need a professional deputy here to be appointed. So we may be instructed to assist with the application. If they say, well, actually, I'd still like to have a go at being a deputy, I think I could do just as good as a job with these professionals, and I can, in doing that, I'm going to avoid all the costs.
I think we had a client several years ago, actually, that worked for one of the banks quite high up in finance, and was applying for deputyship for his mum, who had a trust and pensions, large pensions, and lots of complex financing. But he'd always been managing all of it anyway. And the sister was trying to say that he wasn't able to do it, and I'm sure he ended up getting deputyship because he was able to say, well, this is what I do, and I've been doing it for the past 5 years, 10 years, whatever it is. But I also do this as my day job. You know, so I know what I'm. So you're going to employ my friend as such to do it, and I'm going to have to pay him. You know, that's not in P's best interests. I think he also had some communication from his late father that sort of backed him up to say that this is what we want. But I suppose if you're a qualified financial advisor yourself, why would you pay somebody? I mean, if I was a financial advisor, I wouldn't go and pay a financial advisor to give me financial advice. So why would you pay for that for somebody else? I suppose
something you could do it yourself. And the other benefit is that you know that person better than any professional will ever know them. The professional will meet them once, twice a year, probably be in regular contact with the people around them. But that person around them is going to be yourself. So if you can do it yourself, why not do it yourself? You know what P's best interest.
But if we take our heroin addict son that's not seen mum for 20 years, and he's the only one that applies for deputyship, then the court could say, well, actually, we don't think you're, and that causes contention.
Yes.
Because as a solicitor, you could be then arguing for your client to say, well, actually, he was a drug addict, he's recovered, there's only this amount of money in the bank, actually he's started making contact with his mum, he's doing everything right,
yeah.
You know, actually he is the best person to be.
Yeah, that makes
and you could end up in contention with the court because without a third party, without another party being there as such.
Yes, yeah. It could be the same as well for the financial advisor example. The court may still say, well, we think a professional, then it's not so much contentious, it's just we turn up at the court and put our submissions forward and say actually he is appropriate, and the court will probably say in that example, well, yeah, it makes sense, we've satisfied our concerns here, and then appoint the individual instead of the firm. The other thing is that when you're appointed as a deputy, there's lots of restrictions on the order, so it doesn't just say you're in control of finances, off you go.
Yeah.
As we said, you have to report to them every year to the Office of the Public Guardian.
So you have to have the capability yourself to be able to do that. The young man with heroin addiction may not be able to just follow those orders in a year's time. Yeah,
it may be difficult. It is there's quite a lot of accounting to do for that. It's not too difficult. If you're a lay deputy, the forms are slightly simpler.
Oh, okay.
But the order will also say it will normally restrict anything to do with property, so you can't go out and buy more property, you can't sell piece property without first getting the court's authorisation. Investments, you should always...
Because a lot of people we speak to assume that straight away. I've got the deputyship, therefore I can now go and sell the house.
Yeah.
But they can't, can they? That's not quite... Unless they've asked specifically for that order to be made at the time of the deputyship order being.
Yes, so if you do think that's going to be something that is going to come up during your appointment, definitely stick that in the application from the beginning, that you need permission to sell the property. Obviously you need to explain why, and if the court feel that that's appropriate, then
you've actually just stumbled onto something that is slightly different to what we're talking about, but it happened this week. So we had a Cop 3 come through from a lay deputy, and it had on the what are you asking the order the court? What orders are you asking the court to make? It had about 15 different orders. It was a standard last deputyship for property and financial affairs, but it literally had a list numbered 1 to 15 or 20. It might be. And Kerry brought it through to me and went, how many decisions are on this? Because, you know, these are all independent individual decisions, and we have to assess capacity on decision specific. So if they're putting 15 different orders through, how many separate decisions are there here, sort of thing, and which ones sort of connect up? And I looked at it and I went, this is ChatGPT. And you know, fair play to them that AI is coming. But it's you can't. If you're applying for a deputyship order, it's quite specific what order you're asking for. Breaking it down, and unfortunately, AI, we're seeing it with all sorts of issues where people are sending us letters of instructions that are created by AI that's 30 pages long and full of utter rubbish. But with court orders, you have to be very, very specific on what it is you're asking for, or you risk getting one out of those 15 orders and the other 14 being rejected. I'd like to think in the court of protection it's a bit more, the judges are more on it, and they're more, because they're focused on P's best interest. So if you've done the application slightly wrong, I'd hope that during one of those initial hearings, the judge will say, I think the application maybe needs a bit of tweaking, we'll treat it as this, so it will go in the order then. But normally, to ask for 15 things is a lot. I think normally it's just the appointment of the deputy, then anything significant, so it might be, like say, property, investments, or you do normally get authority to make investments, but that's providing you get advice from financial advisors, whoever. So you can't just go and invest it on yourself by yourself. You need to get expert advice.
Definitely. And the other thing is there's a bond in place when you are appointed, which offers some protection.
I love the fact that if you break that bond, they actually send out Dog the Bounty Hunter.
Oh yeah.
Yeah.
I don't know about dog. Maybe we have had some cases where, unfortunately, losses have been caused. The bond has been called in, the bond is paid out, and then the bond provider has pursued a claim against who it was the deputy and caused the loss to.
Yeah. I mean, this isn't quite like Dog the Bounty Hunter, is it? The TV. This is almost like an insurance policy, isn't it?
Yes.
The bond pays out, and then the bondsman, I don't know, bonds
Yes.
company, they pursue it legally through the courts. They don't send people sort of with assault rifles round to your house and things like that. I'm sure they'll send somebody round to your house to serve you with papers and things like that.
I think that might be the next stage. So the first thing they need to do, once the bond's been paid out, they pursue a claim against you for the loss. Only once they've pursued that claim, then they go on to
and then it's debt collection agency.
Yeah, and that's when Dog the Bounty Hunter comes out.
Didn't he use paintball guns?
I think so, yeah, I remember watching
I'm sure
it.
he'd got arrested. He wasn't allowed to carry a firearm, so he had to carry a paintball gun. It's brilliant. Now, the other contentious side is something that we probably get involved with more than any of the others, to be fair, and that's where P rings up and says,
yes.
I don't need a deputy anymore, I've regained capacity, I've spoken to my deputy and he's told me I'm not allowed to have a capacity assessment, or I'm not allowed to apply for deputyship or to have the deputyship removed. So we see quite a few of those people coming through. Some of those people don't have capacity, and they're very unwell, but they don't understand that, and they're almost serial litigants. We spoke about this, but then you get other people that actually they have regained capacity, or they're very much on their way to regaining capacity, and the deputy, either lay or professional, is just not understanding that or wanting to retain control.
Yeah, so we tend to, sometimes do get involved with those cases. Sometimes it is very difficult because, like I say, sometimes they haven't got capacity. And if they've not got capacity, then it begs the question, can they instruct someone like us to then challenge the deputy because they've not got the capacity? So it can be quite a difficult and complex area.
So then you're almost, before you even take instruction for that, you need to understand whether they've got capacity to instruct.
Yes, that's
before you even go down organising capacity for finances and things like that, and starting the ball rolling for the deputyship being cancelled.
So that's something we do need to consider. Often we'll have a family member, so they may say, well, we're in full support, so maybe the P's wife, husband say that we're in full support of this. So they may choose to instruct us as sort of a litigation friend on behalf of P, and then we can assist them in what they need to do that.
Sorry, let me get that straight in my head. So family then instruct you, so they're responsible for the costs to start with.
That's
until it's proven that P has regained capacity, and then it's
and then
he's in charge of his own cash after that.
So yes, although there's a few more steps. So if it is found that P has regained capacity, there's then a process of us then applying to court. Normally you get the deputy who is appointed to apply to court for them to be discharged. It can be quite a long process because the court then have to agree, because the capacity report, although it confirms P has capacity in this case or doesn't, it's not definitive, so that decision is always there for the court to make. So they need to be satisfied.
I'm so pleased it's not my full ultimate decision. Absolutely, 100%. It's part of the process, isn't it? Not the full thing.
So that's the process. You normally ask the deputies then apply. Sometimes they won't, and then that's where you will get a dispute with the current deputy who says we're still acting, we don't think he's regained capacity. And we've got the capacity report that says he does, so we've got to put in an application to the court to have the deputy discharged and all deputies discharged.
So where does lasting powers of attorney fit in with that? Because we've gone out to see clients where they've got capacity to grant lasting powers of attorney for finances. They may not have capacity to manage their own finances, but they can do that. Or they've regained capacity to manage their own finances, and they've got capacity to grant lasting power of attorney. And that's what they want to do. And in my mind, if you've regained capacity to manage your own finances, understanding the lasting power of attorney is actually, in my mind, is really important, because it prevents needing a deputy later down the road if you lose capacity again for any reason. So in my mind, that's a really good understanding of future risk. But it also is, surely from the court's point of view, they go, oh, well, okay, there's a mitigation in the risk here. This person's regained capacity, but they're also appointing an attorney, so there's oversight still. I think... does that give a stronger case, I suppose? I
think it's certainly supporting, if you make an application for the deputy to be discharged, that would certainly help, because it shows that, yes, you can manage your finances, but you're aware of the risk that should you lose capacity again, you're putting someone in place, this time someone who you've chosen to act, and they can look after your finances, so that would certainly help.
So, and it's about strengthening the case at the end of the day,
yes,
isn't it?
Because you want the court to look at this and go, actually, that is in P's best interest, we'll approve it. Sometimes the other difficulty is that P might have, like say he wants to get capacity assessment because he thinks he's regained capacity, but he hasn't, and the deputy's stopping the capacity assessments, or maybe the deputy and him have fallen out. And we'd sometimes get involved in those applications to appoint a new deputy.
Because it's not that the deputyship isn't required, it's just the relationship.
The relationship's broken down. So why not appoint a new deputy who you can go off and find that you have a better relationship with and can work with. And the court are often sort of agreeable to that. And normally if a professional deputy, you'd hope if they were met by that application, unless they had any real concerns, they could say, well, they're going to have another professional deputy appointed, they've got that protection. If they're more happy with them, then we'd be willing to let it go.
Because we see this where you have a professional deputy, it's horrible, there's always a large amount of money involved. And then you've got family behind that doesn't really understand capacity, but they pay their own phone bill. You know, they're doing their own shopping. You know, they're doing everything that I do because I've got £500 in the bank, and you know, I pay my mortgage and I pay my bills. He does the exact same, so therefore he must have capacity. You know, what's the issue there? And the family are almost pushing for that discharge as much as P does. But actually they're not understanding that if you drop £3 million into that guy's bank account tomorrow, they will just go and get rid of it as quickly as possible. And they will give it to anyone and everyone, because the amount and the investments are so complex, and it's that bit that they don't understand. And I think as somebody that hasn't got £3 million worth of investments, it's difficult to then understand, you know, well, they can do everything that I can do. They've got capacity to manage their day-to-day finances, so therefore they must have capacity. And it's that contention that we see between the family and the deputy. It's not always P, it's the family and the deputy that causes that relationship breakdown.
We sometimes, I think it's helpful in those cases to share the capacity report. So where the reports are really helpful in explaining why they've reached that decision, the family can look at that and see, well, actually now I understand. Probably might still not agree, but it can be a bit tricky, because then do you want to reveal how much P actually has? They might think he's only got a few thousand, but really, which
then means you could be putting him at further risk.
Because then they think, oh well, he's got £3 million. I'm definitely going to go after that now.
And actually, I'm going to be coming around for fish and chips every night of the week. Next time we go out, he can pay for this and he can pay for that. But I suppose that could potentially lead to daily abuse almost, if they're aware, you know, actually he's got £3 million sitting in the bank.
So you just have to be careful how you approach that and what information you do give. Sometimes you might redact certain information, but when you are, if it does go to the court, I think the court's view is that unless there is a real risk, there needs to be complete transparency to everyone. Because the other way around, the family might say, well, we'll act as deputy, realise there's £3 million and say, well, actually, I don't want to touch that.
Well, I hadn't even thought about it the other way around, that actually you could end up, without that transparency, you could end up going all the way through that contentious litigation for the family to get to the court hearing and go, how much? No, no, I thought he had, like, you know, just PIP coming in. I thought that was it. Then you've just wasted the entire court's time, caused them a huge amount of stress, a massive loss of cash.
Yeah.
Because you haven't been transparent with the family to begin with.
No, that's why all the forms there do list all the details. So if you are served as a respondent, someone who responds to it, not just being notified, you'll get that application. You will see how much is in each one.
We're being given a time warning. It's genuinely like having Carl Pilkington, honestly. Oh my! I've said that joke so many times, and she still hasn't watched any of it, so she doesn't know who Carl Pilkington is.
Oh, you need to watch that. Is it an Idiot Abroad?
Yeah, an Idiot Abroad.
Great.
Tin Pot Radio.
Yeah.
If you want to listen to a good podcast, Tin Pot Radio. It's on Spotify. So are we. See, I'm getting good at these links now.
Yes.
Yeah. I genuinely, some of the points you made, I hadn't even thought about. I love sitting and doing these with guys like yourself, because we obviously see one side of the court process, and then it disappears. We do the capacity assessment.
Yeah.
I mean, 99.99% of the time, we never find out if that person even gets a deputyship.
Must be frustrating.
I think we've had somebody come back once about a testamentary capacity will and said, "Oh, by the way, it worked. They tried to contest it. They saw your report and stopped the contesting." But we very rarely hear any outcome from anything. So it's kind of nice to know what the rest of the process is. I suppose if you've got people out there that are considering contesting a deputyship for any of those reasons, what's your top 10 picks? What's your best advice?
I think the first thing is probably get some legal advice from a solicitor. Because we'll be out. Each case falls on their facts, so it was specific. So it's hard to give generic advice, because what works in one case probably won't or may not work in another case. So I think that'd be the first tip: get some advice, even if it's just a phone call. Not
from AI.
No, don't use that. So we had an example recently. A guy sent me an application he'd done, and he used AI. And he printed out. I think he submitted the application with the AI things in the bottom.
Oh no!
So it had all the links.
So it said, "This is what I think you should do."
Yeah. And at the end, it said, "I think you've got a 75 to 80% chance of success." And we looked at it before I seen this AI step, and I said, "This is less than 50% chance." And AI is giving him this high thing, and he's like, "Right, let's go for it." And I'm like, "Okay."
Yeah. I think they named this wrong. It's not AI. It's a language model. It's about words. It's not giving genuine advice.
So I mean, it's
solicitor legal advice.
Yes, proper legal advice, and just always come back to: is it in P's best interest? So you might not like the person who's going to be appointed or has applied to be deputy. But that doesn't matter. Is it in P's best interest? Can they do a good job? Can they manage the finances? If so, then okay, let them do it. Why sort of cause more dispute?
And you need to take your emotion out of that, don't you? Which is very difficult. But sitting down with a pen and paper and actually writing down. These are the pros and these are the cons can help, because you need to take the emotion out of the situation, even though it's very difficult.
Yeah, definitely for property and finances. So that would be. For health and welfare, maybe the emotions come into it a bit more, because maybe someone's preventing someone from having contact, and you want to get contact back. That's when it is a bit more.
We're going to have to do another one of these just purely on health and welfare, I think. But actually, you've touched on it now, and it's made me think. So a lot of people think health and welfare is purely about making medical decisions and whether mum goes to a care home or not.
Yes.
But it's not, is it? A health and welfare deputy can make a huge amount of decisions, can't they?
Yes, they can. And again, the order will be quite restrictive. It will say what you can and can't do. But typical stuff would be medical treatment, just overall care plans, where you live. That could be: do you live at home with family, on your own? Do you go in a care home? What care home? Sometimes this is generally excluded, but who you have contact or who you
and for younger people rather than Doris that's in a care home with dementia. These are really important orders, aren't they? Because who you can have contact with is a huge impact on your life if you're 25, 26 years old. If you're in your 90s, it may not have such a huge impact, but in your 20s, it's going to, a health and welfare order is everything.
And it's not just care homes, they say, it's for sort of elderly people. Younger people might have schools they go to, sort of therapy, so it's all those sort of decisions. And if you're a health and welfare deputy, you've really got to work with the property and finance if there's separate, because you can make all these care plan arrangements, but you need to have the funding in place to do that.
And health and welfare and property and finances are, because they're getting more entwined as the court of protection sort of grows as such, aren't they? And you're right. You can't say, well, my son needs 24-hour, 7 days a week care from 4 people to cost it, and he's only got 50 quid in the bank. It has to be funded. It can't just be, this is what he needs. I've decided, therefore you have to find money for it.
And sometimes you find on the flip, property and finance deputies are having to become involved with those decisions because the care people may be saying he needs occupational therapy, for example, once a week. It's going to cost £2,000. We know, the deputy knows it's in P's best interest for that. That's what the care team is saying, but have they got £2,000 or whatever to afford it?
We're seeing a lot more requests come through for care assessments and funding assessments, so brokerage reports, to identify actually what care is it that's actually needed. How much is this going to cost from not just this one provider but for three or 4 providers, because the financial deputy is trying to make a decision and they're relying on a care provider to give them that, but it's one care provider's opinion. And they have got a vested interest in that sometimes. So we're seeing more and more care assessments coming through for financial deputies trying to make some sort of financial decision about health and welfare provision.
I guess
I think that's the right way of putting it.
Because it almost then sort of not ticks the box, but it says, well, these are what I've been told I should be doing. These are the finances, and I'm making it work within. So I'm approving that expenditure because that's what the advice is. I've not just gone off and made these decisions.
In fact, as we've talked about, we've got Nellie Plus, our case management, and it was set up. We thought it was a lovely idea. The idea was that if Mrs. Smith goes into a care home and her son lives in London and she's in Manchester, we'll pop in once a month, make sure everything's okay, see if she needs anything, report back to the attorney or the deputy, and then they can pay and organise for it. And it sounds lovely. It's not how it's worked. What's actually happened is where we've ended up with issues like that, where we've got a financial deputy, we've got a care provider saying, he needs this, and this, and the deputy's going, I don't know. Then the local, and everybody's arguing with everyone else, and they've dropped us in to go, can you manage this situation and actually tell us what he actually needs, what provision is required, sort of thing. So we're seeing, like I said, we're seeing a lot more financial deputies having to become involved in the decisions, because they can't get involved in organising care, can they?
No.
It's about paying for the right care.
And making funds available to make sure they're being spent properly in P's best interest. And those assessments are really good for the applications, because if they do become disputed, you can say, well, I've gone off, I've got the advice about care. The care arrangement's not so much a matter for the property and finance proceedings, but I know what the costs are, I've done some projections, and this is how it all works. So it does help with...
I think we're going to have to wrap it up. Fumi's waving at me. But genuinely, I think we need to do another one on health and welfare deputies, pure and simple, and purely on health and welfare. Thank you so much. Genuinely, I found it interesting. I don't know if the 80-odd people that are on have found it interesting, but I have. And that's all that matters. Thank you so much for joining us. We're back next month. We've got a slightly special guest next month. We've got a gentleman, I can't remember his name off the top of my head, Richard Russell, who is the son of a lady who went through the care process and went through care funding, and he had to fight tooth and nail with the ICBs and things like that. So it's the first time we've not had a professional on that. We've got the local authorities say service user, I hate that term, but somebody with lived experience.
Yes.
That's the
local authority use client now.
Do they? Are they started to use client again? Right, okay. But yeah, we have somebody with lived experience coming on to talk about continuing healthcare and ICBs and capacity and all sorts of different things. So it's going to be really, really interesting, that one. So please do keep your eye out. Fumi will be sending out emails and text messages and Instagram messages and goodness knows what else. So please keep your eyes out, and it will be on Eventbrite as normal, so please book your tickets for that. It will be good. And then I don't know what we've got the month after that, but we will have something the month. Kirsty Finley. Oh, the death planner.
Yeah, no.
Oh no! Oh yeah! No, absolutely. Kirsty Finley the month after that, who is Kirsty's really interesting. She is a local authority social worker that's left local authority, become an independent practitioner like us because we're awesome.
Yeah.
And she does serious safeguarding investigations and reports
independently.
Yeah.
Wow.
So if a child or an adult dies or is seriously injured, she does the reports around it. So that I'm genuinely intrigued by. So yeah, that's going to be really interesting as well. So keep your eyes out for that one. And then we have NellieCon in October. It was November last year, Fumi, give me a break. In October, we're still organising speakers and things like that, but it's our fourth one. It was awesome last year. It's going to be even better this year. So please go on to Google NellieCon and it pops straight up. Book your tickets because we're selling fairly quickly actually this year compared to last year, which took until about November to sell the tickets. This year we're doing they're selling. So please get on there, book your tickets, and we will see you next month with our next Nellie on the Sofa. Thank you for your time.